associate at T&D Legal, a commercial firm based in Vietnam. We have Monia Belkacem from Pistres Law, based in France. We have David Liu from Duan and Duan in China. We have Alexander Blum-Rosen, who leads a team of international lawyers at Polaris Law, a law firm in Paris. We have Leonard Sande and Silva, a partner at FB and Associados in Lisbon, Portugal. We have Peter Rogel, founding partner at Rogel Partner in Zurich. And last but not least, we have Christian Balecher, the managing partner at Christian Balecher, a legal compliance firm based in Switzerland as well. Just to acknowledge two others who are joining us shortly, we have Marcin Milzurek, who is a partner from Marcin Milzurek in Poland, and Vasco Cardoso, who's a managing partner at Leal Cardoso. I'm sorry for that. I seemed to have been cut off. I'm not sure what happened there. I was just going through some of the housekeeping rules before we start. So I was saying that the panel will take questions in a short Q&A following the discussion. So kindly send in your questions by using the Q&A section, and there will also be a recording made of this session. Kindly, if you're in attendance, or kindly leave a comment in the chat section telling us where you're listening in from. And if you'd like to tweet or post about what the panelists are saying, please use the hashtag WLAData22. Okay, now that that's out of the way, just to start. So privacy issues, for better or for worse, are now front and center in the news and in users' everyday lives, perhaps as never before. Consumers are increasingly becoming dissatisfied with the unspoken bargain that led to third-party misuses of their data, and are demanding greater rights to control how such parties collect and use their personally identifiable information. I think you will all agree that digital privacy largely existed under the model of industry self-regulation, but laws and regulations emerged and continue to do so to address this increasing misuses and concerns of personal information and the unintended consequences that followed from technology and innovation. I think a great place to start would be to just have a general overview on the rules and regulations that are securing information and maintaining privacy, and some of the challenges facing implementation of these laws and regulations. So Seppo, if I may start with you, what is the current privacy and data protection landscape in Finland? And has there been a cultural shift towards safeguarding personal data?
Hi all. As you know, Finland is part of European Union, so we have this General Data Protection Regulation, GDPR, in Finland, and GDPR is giving protection of natural persons for the processing of personal data and also the free movement of personal data. So all the EU countries had to transport GDPR into local national law by May 2018. So we have also own law here in Finland. And based on some surveys made by European Union, more than 90% of Europeans say they want to have same data protection rights, regardless of where the data is processed. If I look what has happened, I'm doing business law in Finland, but also in Europe. there has been a huge cultural shift inside European Union, but also between European Union areas that are outside the European Union. And the shift is that EU is strengthening the individual fundamental rights in the digital age, and also facilitate businesses trying to clarify the rules for companies and bodies just to make this digital single market development. So I think there has been a development from EU side to impact other areas outside EU to go away with this current fragmentation in different national systems and unnecessary administrative burdens. In Finland and also in other EU countries, they have set up national bodies to responsible for protecting personal data. So a lot of things has happened.
Okay, thank you very much, Seppo. Thanks for that insight. Perhaps, Bao, might you give us your point of view from Vietnam?
Yes. First, I want to thank Seppo for your sharing. And Vietnam is still under an emerging market, especially from a digital era. So when we speak about the personal data regime, I think there are 7 aspects that we mostly cover, even in GDPR. It's include the definition on personal data, the conditions for processing one's data, the data subjects right and restriction, and data processing right and restrictions. And then we have the supervision mechanisms in the governmental bodies. And we have cross-border data transfer, and then administrative file. We all have all of that under the Vietnamese law, but unlike the GDPR, it doesn't set out very specifically to what extent that the data processor and the data subject is entitled to or is responsible for. So it's still in a very vague, and we are currently expect a more consolidated piece of legislation to govern these incremental objects. So that's the current climate in Vietnam, and I think the draft decree on BDP decree would be expected to be enacted soon, probably by the end of this year.
Thank you very much, Bao, for just that short remark on the current landscape in Vietnam. I'm just curious to know, and perhaps this will go to Munia Belkacem. Perhaps she can give us a perspective from France. She also can share, perhaps, if you could, Munia, your perspective from Morocco on the same as well, and perhaps also maybe highlight some of the present challenges the 2 countries are facing in implementation of the privacy and data protection as well.
Well, in France, so the French Act of 20 June 2018 incorporates the GDPR provisions in the existing Act of 6 January 1978 on information technology. And thanks to the GDPR, French citizens have the following rights protected: the right to be informed, the right to access, to rectification, to erasure, to object or opt out, a new right to data portability, and to the restriction of processing. We can say that it made a real cultural shift, since people are aware of their rights and are aware of the possibility to file a complaint against organizations violating their rights. In the same time, organizations have contributed to that cultural shift, because we made the data protection compliance in the center of any decision taken by organizations in their management, so they can comply with the legislation. And to ensure that new landscape, the French supervisory authority, named the CNIL, controls the compliance with regulation in data protection to all data subjects residing in France. And the CNIL regularly publishes guidance on its website so that organizations have more concrete information on how they can process with personal data. And the CNIL has established a regime of strict scrutiny over the processing and has already sanctioned several violations in breach of the legislation. For example, on 21 January 2019, the French authority imposed a financial penalty of 50 million euros against Google in accordance with the GDPR for lack of transparency, inadequate information, and a lack of valid consent regarding personalized advertising. And this decision has been validated by the Conseil d'État. So it gives a secured landscape and a secured future for data protection in France, which means for organizations, do not mess with data protection regulations. In the same time, in Morocco, I think this is the same landscape than in France. The governing law is older than the GDPR. This is the law number 0908 on the protection of individuals with regard to the processing of personal data. And the regulator in the Moroccan is the Moroccan Data Protection Authority, named the CNDP. And that law, the governing law, provides a general framework for personal data protection and is particularly comprehensive with respect to the circumstances under which consultation with the CNDP for organization is required before organizations engage with data processing activities. So the CNDP is responsible for monitoring compliance with the law and has been active in issuing guidance on several topics such as biometric data, direct marketing, etc. From a regulatory perspective, I'm sure the data protection equation in France or in Morocco or everywhere in the world will never be solved because the world is constantly changing, and therefore the data protection landscape is never white and never black as long as we adapt those rules to our world. And finally, from a business client perspective, as lawyers, I would say that most of the time we assume the role of data protection officers for our clients' need advices to comply with data protection rules. And it can be difficult since we must be formed as lawyers and informed in data protection regulations. So I think that is the challenge today as lawyers.
Indeed, Monia, thank you very much for that very insightful representation of what it looks like in France and Morocco as well. I would just like to pose a question to all the panelists, maybe just for a quick 1 or 2 minute comment, please. Just noting that there are numerous challenges. Perhaps Monia and Nguyen and Seppo didn't quite highlight all, but noting that there's numerous challenges involved in balancing the demands of business with privacy policy and the broader reputational interests. We definitely therefore need regulation that protects the safety of consumers, all while supporting innovation and creating a conducive environment. My question is, how are governments, are businesses, users responding to the role of the data protection regulator as investigator, as the arbiter, and as well as the executioner? Perhaps I'd have Alexander. Could you kindly give me your comments on that, please?
Sure. Good morning, Alex Blumrosen from Paris. Excellent question. The users at least the ones I've seen in France and the United States, because I'm admitted to Paris where I practice, and I'm still admitted to the United States bar, the New York bar, have really taken stock of GDPR over the last not just 4 years since it was adopted, but really since the privacy regulations in Europe began in earnest, early on with the French law that Munia referred to back in 1976, and then with the 1995 EU privacy directive. One of the interesting facets of all of European privacy law is that it decentralizes the responsibility for compliance to companies and to the parties that are subject to the law. And so those parties need to be informed about what the laws are and need to implement steps and procedures in their internal businesses and in their relationships with others in order to come into compliance. And there is a whole architecture of processes that European companies, and French companies in particular, have adopted, starting in order to do this, starting with the appointment of data protection officers, which in some cases in French law is required, in some cases it's optional, but there are literally tens of thousands of data protection officers in discrete individual companies around France whose job it is to oversee the compliance with the GDPR. Now, sometimes it's their only job. Sometimes they accumulate the responsibilities of general counsel, legal jobs, compliance jobs, but it has changed the landscape of France to have a whole demographic of individuals whose mission it is and whose legal obligation it is to make sure that companies are in compliance. And I think for later on, we can go into what that compliance looks like, what they do, how they respond to different challenges. But I think that's a fundamental change that we've seen over the last 30 years.
Okay, great. Thanks, Alexander. Perhaps Christian, might I have your intervention as well?
Sure. Thank you. I'm Christian Berlacher. I'm data protection service provider and other compliance provider here in Switzerland. As the EU did in 2018, Switzerland has now come up with a new data protection act, law on data protection. Following those developments, the EU has done, and companies now start to look at this new and to adopt processes and procedures and also measures provided by this new legislation. However, Switzerland, as you may know, is one of the first countries that had introduced data protection legislation. And the old, since I think 1995 or before, and data protection has been on the agenda of companies already since a long time. Now they realize just that they can really introduce new instruments and new measures. As was mentioned before, the new law also gives the opportunity to have a data protection officer and offer some benefits to companies if they have that. The new law describes in more detail what the measures are to protect personal data a company does process, like gives some indication of organizational and technical measures they should adopt to protect the data and to ensure security of the infrastructure where they store the data. Then it does provide also for, or suggest that they do a risk assessment before they change some or set up new data processes. And of course, course, they need to have processing manuals and processing procedures when they process personal data, etc. So the new law will be more detailed and will offer detailed and concrete indications on what to do and how to comply with data protection legislation. We also have a regulator, of course, in Switzerland, and the regulator is very active and does also provide for guidance and proposals for policies and procedures.
All right, Christian, thank you. I was just thinking perhaps I should also get a perspective from Leonor, seeing as she comes from Portugal. It'll be good to see what's happening there as well. Perhaps you can also highlight your landscape, maybe some of the challenges you're facing there, and just how the regulator and how businesses and the government and just generally consumers are responding to data protection.
Yes, good morning. Thank you for this opportunity. First, I think, as you know, Portugal is a small country. My experience is based on small companies, especially. But I think we also apply the RGPD, and we also have organizations that are now applying or trying to apply the European legislation. But the most challenge here in Portugal, the most important challenge is to apply the legislation. Here, most of the companies have a difficulty to understand the legislation, and the most important challenge that I'm facing along the years is to explain and to demonstrate the companies and also the citizens why we need to apply the legislation, and for example, what is the most important value on to protect the information that companies share with others, and mainly the purpose to purpose to protect the information and the personal data. I think the most important challenge that we are facing now in Portugal is to apply the law and to inform the natural persons why that information, why personal data are so important and so valuable in the market and in Europe. We have the legislation. We try to apply the legislation, but if people don't understand and don't reach the message, it's very difficult sometimes for us lawyers to implement and to transmit and to inform the companies, our clients, the need to apply the legislation. For now in Portugal, we don't have several court decisions or several decisions. As for instance, in France, I believe that according to the perspective that was given, I believe they are more evolved than Portugal. In Portugal, the process is still slow, but I believe that we are getting there. For instance, in the present, we are facing several cyber attacks in hospitals, in telecommunications, and people are more aware of the problem, and people are getting more conscious, but I think it's a very slow process here in Portugal.
All right, thank you, Leonor. I was wondering, perhaps I could shoot this to perhaps Nguyen. I was just wondering, for Vietnam being an emerging market, has your regulator commenced enforcement in terms of any breaches that might be occurring within your jurisdiction?
Yes, it's interesting questions. So firstly, we talk about the cultural. So the cultural in Vietnam and the developments in the past, the data privacy is not an utmost concern both from the citizens and from the regulators. But within the 5 or 10 years up to now, there has been a recent uptick of the digital platform, e-commerce, and this has raised the awareness of how important is data privacy is. And the regulators enforce some many rules governing about the data information, data protection, and some of them overlapping. And the most controversial one is about the cybersecurity law, where we put the local data localizations as part of the efforts to control the data. So many giants like Facebook, Google, some of them under some circumstances that needs to put a server in Vietnam to localize the data here that they process via the service that they render, like the marketing, advertising, and they collect information from that. So from an overall perspective, I think that the regulator is responding to the needs of regulating the data protection, but they are quite confused on how to go, whether they go with the GDPR, whether they go with the, let's say, the Chinese approach, and they are quite confused about that. So there has been gap and overlapping even in the regulatory authorities. So most of the actual enforcement has been concerned about the national security, and also, yeah, most of them are concerned about national security.
All right, thank you, Nguyen. And I was just thinking, perhaps, after the pandemic, there's been a lot of collection of metadata and a lot of the work that was going on in terms of contact tracing. Do you think that this particular issue brought it home to the public to realize that indeed there is something that needs to be protected around with their data, and will we also need regulation around this?
Yeah, I think I really like one sentence that the crisis triggers awareness. So without crisis brings a lot of things to adverse things to most of the people, but we have to see it from some positive way. It triggers the awareness, that the motivation that motivates the government to quickly adopt the regulation to protect data privacy. And after the pandemic, where most information has been obtained and transferred and processed virtually, the need is become urgent than ever. So I think you are correct. The pandemic has made the regulators as well as the citizens aware that they need to take some actions to protect their own data and to comply with the rules rather than just practically, not theoretically.
Yeah, and just to, what Leonor alluded to in her intervention, she mentioned that she is also having challenges as well because citizens there, the public, were not taking privacy, data protection seriously.
Yes,
yeah, go on, Leonor.
Here in Portugal, we are facing another problem that is serious in my perspective, that now we are facing several cyber attacks. In health, in telecommunications, and now people are more aware of, they start questioning, where are my personal data, if my personal data were affected or not. And we have here a lack of information. We are not providing serious information to the natural person, to the citizens. We see the news, and we know, for instance, that Vodafone has a cyber attack. But however, for instance, I'm Vodafone client, and I'm not aware if my personal data were transferred for another country, if, for instance, was erased. I'm not aware of anything. I already questioned, for example, Vodafone, and they are not responding, and they are not responding to my emails or to my questions. So here now we are facing a serious problem concerning cyber attacks, and people are more aware. But I think companies, international companies, need to have a more careful to provide citizens the information they need, even to understand what are their rights, even saying that you need to be informed of your personal data, that your personal data is safe or not. So that is the most important challenge that we are facing here in Portugal, not due to the pandemic or to the crisis here in Portugal, but due to the cyber attacks that we are now facing here in Portugal. So.
Oh, thank you, Leonor. I would say in Kenya, we're having similar challenges as well. But I would say ours are more of a funding issue. Our regulator is not properly funded. Therefore, they're not able to properly educate, do this awareness for the public on matters, privacy and data protection. And therefore, you find a lot of people are not picking it up or don't quite understand what it means or how it works. So I do definitely understand
I think the most important challenge for me, in my perspective, is to simplify the information. We need to create the information more simple, more accessible to people, to normal people, so that they understand why, for example, they need to express their consent to certain data. So why, for instance, in certain circumstances, you don't need your consent to process your information. People ask me all the time the same questions. So I believe that the legislation is not simple. It's not, people try to read, but they don't understand. They don't reach the importance, and they don't reach how the companies will process your information and why. Most people ask me why. So I think the most important challenge in practical terms, since the legislation already exists, and we have here in Portugal several legislations regarding personal data, but I think the most important challenge is to create a simple information that people can understand, the why, the purposes, why do you need sometimes why do you need the consent, others why we don't need the consent. So that's very important to explain people. We are protecting their rights, so they need to know why, when they will exercise their rights. I think that's the most important challenge that we are facing now.
Right, definitely. Perhaps
maybe I can add just add a quick little word to Leonor, because the why is obviously very, very important. Yes. And I would add that who is also very important.
Very important, yes. Yes.
Because one of the very interesting things about the GDPR is that because it is decentralized, because companies have the DPOs, no one is exactly sure who is responsible for what. If I take the example of an arbitration or a commercial transaction, so it's one thing when a company has a DPO and ensures compliance, but what happens in an arbitration when the company sues another company in arbitration, and all of a sudden you have the exchange of personal data in the context of a proceeding, and all of a sudden no one knows who is responsible for compliance with the GDPR. Is it the original company that collected the data? Is it the arbitration institution? And all the arbitration institutions right now around the world are concerned because they could be subject to sanctions going up to 4% of their revenues as provided in the GDPR if they don't comply. Or is it the arbitrators, which makes me and all my fellow arbitrators in litigation very concerned, because as arbitrators we are trained to give out and to pronounce judgments, awards that are valid internationally, but we are not often, I may be an exception, trained GDPR and data protection specialists. And so there is a great concern among the arbitration community, whether it's institutions, arbitrators, or even parties who do have some tools, about who is responsible. And the responsibility generally is so diffuse, so decentralized, that we get back to that adage where everyone is responsible, no one is responsible. And I've seen in practice a number of areas where companies, purchasers, sellers say, oh, well, it's not my job, someone will take care of it. And we get back to the why of Leonor. If we need to be more clear about who is responsible, so that people who are responsible can take the necessary steps. And often that's not being done.
Yes.
Maybe
I agree.
Maybe I can go back to you, Valerie, you
Yes,
mentioning whether the COVID crisis has had some impact on the data protection regime. So as I can speak from my experience here in Switzerland, I think what the COVID crisis learned us here in Switzerland, and I'm sure that was also the case in Europe, is that there are two different kinds of personal data defined in our legislation. We have general personal data and we have sensitive personal data. And health data is sensitive personal data. And sensitive personal data has to be protected in a different way than the general personal data. And it has many more requirements and restrictions to transfer and to disclosure. So in reaction to the COVID crisis, for example, our government wanted to introduce an app which gives users quick information on the COVID status of their surrounding other human beings. And the app was delayed because they couldn't overcome the data protection questions and had very difficult time to introduce the appropriate measures to protect the health data, which of course was possessed by this app. The same was later with the COVID certificate and with other projects and reactions from the private initiatives to react to the crisis had been started, but then it had to be abolished because they couldn't overcome the data protection. So I think one learning we had from the crisis, that there is a whole set of sensitive personal data which we really have to protect with very strict measures.
Right. Thank you, Christian, for sharing your learnings, especially from the pandemic, for sharing that with us. This is just for the attendees who may be joining in the middle of the session. Just to let you know that the panel can take your questions in a short Q&A, which follows after the discussions. So kindly send in your questions through the Q&A section. Also, just to let you know that this session is being recorded. Kindly leave a comment as well in the chat section, letting us know where you're listening in from. And if you would like to tweet or to share what the panelists are saying, please use the hashtag WLAdata22. So we're already out of time with the first segment. So I would like to move on to the next segment. And this is on cross-border data transfers. And we've seen laws and regulations and privacy, especially online privacy, the different levels, I would say, of privacy regulations in different jurisdictions clashing, especially in cases of cross-border data transfers leading to international data breaches or halting businesses and so on. So Leonor, I'd like, if I may ask, what constraints are organizations or privacy practitioners or just lawyers like yourself are faced with in terms of cross-border data transfers, and how these challenges been addressed or circumvented?
From my experience, we have a regulator here in Portugal that already faced several problems regarding the transference of personal data to other countries, namely the United States. Because the decision that was promoted by the Commission took us all by surprise when they conclude that the privacy shield doesn't comply with all the safety measures and all the regulations that were foreseen in RGPD. From my experience, I have a client, or I took care of several issues regarding a client that was related with the Ministry of Education, processing personal data from children in several schools. So when they heard about that decision, they were very alert. And we have to initiate all the procedure regarding the transfer for personal data, because the server and the personal data were took care of or were treated in United States. So now we already asked our regulator to inform us how to proceed, and in fact, is very, and for what I see, we are now trying to apply the safeguard, the standard clause, and we are complying with this standard clause that are already foreseen in European legislation. Nevertheless, I think in practical terms, to implement the standard clause is very difficult, because as my colleague already spoke and already told previously, we are facing a culture, different cultures from different countries. We see personal data from different perspectives. For example, the United States have a different perspective on how to treat and how to proceed personal data and how to safeguard personal data in their country that are absolutely different from us. So the standard clause are indeed and are in fact a solution, a previous solution, a better solution to apply in the present and now. However, in the future, I believe that we are still continuing facing several problems, and the most important problem is a cultural a cultural problem, because for instance, United States and namely the Facebook, so in the United States, they don't have any problem to share personal data for legal authorities, for instance, because their interpretation is to see the purpose of that treatment as a legal treatment, as okay, if we share the personal data to any legal authority, regardless the purpose, okay, for us it's okay because we believe in our institutions. For instance, here in European, we as European don't think like that. So I think the most important challenge is to try to find a middle solution between different cultures, and to provide safeguards and to provide all the legal rights to European citizens. Nevertheless, we are applying the standard clause. I think it's a solution, despite the complexity of the standard clause, because it's very difficult in practical terms to prepare standard clause for certain data information. But I think that's it's a very important challenge that we are facing now, and I believe that we will face in the future, because we cannot change different cultures, we cannot change different governments, but I think that's the most important challenge. But for now, we here in Portugal, we are applying the standard clause according to the legislation applied. Nevertheless, it's difficult, it's very complex, and as I mentioned before, is not a simple information to provide to our clients. Sorry, I start to speak. Sorry.
No, it's okay. There's no problem with that. It's good to have your perspective, and a very insightful perspective from the Portugal point of view. I think I would like to hear from Peter Rogel, and just to see what's happening in Switzerland. Are you having any constraints in, of course, for Switzerland, it's still the GDPR, any constraints with cross-border data transfers, and particularly the use of the safeguard, as Leonard has alluded to, of the use of standard contractual clauses. Are you having constraints implementing that? Is Switzerland also adopting adequacy decisions or binding corporate rules? What's happening there, Peter?
Yes, thank you. We have, as Christian already said, the new data protection law is quite similar to the European one, because we are quite close to the European Union anyhow, and we take over the law in this respect, or in other words, to make it easier for us to have transnational data transfer. So our government set up some kind of concept of adequate protection. If abroad in the other country, the receiving country is adequate protection, then it's allowed. And if there is no adequate protection, there have to be certain rules to be observed. So what was done in order to get this idea, to fulfill that adequate protection idea with material stuff, the government or the data protection officer here set up a list of countries where we have an adequate protection level. And that's quite easy. Whenever a receiving country is on that list, then it's quite easy to transfer the data. And if it's not, then all these kind of things have to be observed according to the law, meaning there are it has to be at least an adequate protection level. That has to be done through different kind of principle that have to be fulfilled, including principle of legality, of guarantee of legal recourse to a court and things like that. So in other words, whenever the country is not on the list, such as the United States, these kind of things have to be observed, and if not, then other measures have to be taken. And if this is not possible, then the data transfer is not allowed. So we have some kind of a tree to see is it allowed or is it not allowed. The good thing is actually the government also provided some forms to see or to check that if maybe that would be feasible, the data transfer or not. And as also Christian said, our data protection officer is quite friendly in this respect. Whenever you have an issue, and you can address that to the data protection officer. Standard protection, this clause, the standard contractual clause that's used, that is allowed, that will provide adequate protection. What is not providing, clearly not providing adequate protection is internal corporate binding rules. This is not something which is allowed, or which will not bring you to an adequate protection level. And at the end, finally, then the company needs to take measures on a technical level, meaning that no local government shall have access to the data. But I've never seen such a case that this would be possible. I mean, it is basically technically possible, but you know, I believe that's not the doable way. Sorry, my voice. So I stop. Sorry.
No problem, Peter. We heard you very clearly. Thank you for. Okay, just moving on. Alexander, I know you have been following this particular topic on cross-border transfer, cross-border, the litigation that arises from it, and you've served as arbitrator and litigator in complex cross-border litigation in this space for many years. So looking back at the EU-US Privacy Shield framework, the 2020 Schrems II decision, and Data Protection Commissioner versus Facebook Ireland, and the joint announcement on was it March 25th by the President of the US, Joe Biden, and European Commissioner Ursula on the possibility of a 2022 data protection framework. I know the devils are in the detail, and I don't, as of today, I'm not sure yet that there's any text to that accord available to provide any specifics about the new framework. What are the lessons that jurisdictions may borrow from just seeing from the past and how things have moved on from the Privacy Shield to the Schrems II up to where we are today? What lessons can other jurisdictions borrow from this?
Well, first of all, I'd like to say that there is quite a bit of uncertainty right now, which is very troubling. The commercial relationship between the EU and the United States is one of the motors of world economic growth. And a lot of that is based on the transfer of data going back and forth. Now, as Peter very well said, under the GDPR, there is a data tree, a decision tree, to figure out exactly what constraints, what conditions are put on transfers of data from Europe to the United States. Obviously, data transfers within the EU are free. Data transfers outside of the EU need to meet conditions. Either one, you're going to a country that has an adequacy decision, that is the European Commission, on the advice of the EDPB, the European Data Protection Board, has ruled that the destination country has adequate safeguards. And then it's very simple, and the data can be transferred as if the data is within the EU and being transferred within the EU. If there is no adequacy decision, then you need to put in place other procedures, binding corporate rules, work in the EU, or the standard model clauses. And for the United States, it was a little bit complicated because the European Union did not provide, this is before the Schrems II decision, did not provide a full and complete adequacy decision. They were reviewing the adequacy of United States privacy rules on a yearly basis, and provided and agreed with the United States that there could be this privacy shield process that would provide adequate safeguards. And so the privacy shield for transfers between the EU and the United States became the equivalent of the binding corporate rules or the model clauses. It was another way that US companies could come into compliance with the GDPR. And over 3,000 American companies signed up for that process. Now, you mentioned the arbitration of disputes. One of the, and I think the architecture of that transfer process and of the privacy shield was very good, and it worked very well. And one of the aspects of the privacy shield, which we have in Europe under EU law, and which is part of data protection law generally, is that there has to be redress, proper redress. And one of the problems with the United States is that there had never been sufficient proper redress given to EU nationals about their data protection when there was an issue in the United States. And so one of the things that the United States did in establishing the privacy shield was to provide 6 or 7 different types of protection, redress for European nationals who had difficulties concerning their personal data. There is an appeal to the company. There is an appeal to the Federal Trade Commission. There is the availability of private companies that resolve data protection disputes. And then there is the arbitration solution, which is an arbitration panel, a special arbitration panel with 22 arbitrators that were selected jointly by the European Commission and the United States Department of Commerce to resolve privacy disputes brought by EU nationals against certain practices in the United States. And so I am indeed on that privacy arbitration panel. The privacy panel has never had a case, unfortunately for us privacy arbitrators. The system is there. There is a system of arbitration rules that were developed by the ICDR, the International Center for Dispute Resolution, which is the international affiliate of the AAA, the American Arbitration Association. So on the ICDR site, you can see what the arbitration system is like, but it has never been implemented. But as I was saying, all of this worked very, very well. The problem was not with this part of private compliance or company compliance with GDPR rules. The problem was with the state interests on the United States side, and frankly, sovereign interests worldwide, because sovereigns collect data. They collect data to fight terrorism. They collect data to fight drug trafficking. They collect data to identify tax schemes that might be illegal and might be stealing revenue from their country. And along the way, as they are looking into data that is being transferred across their borders, they are looking at personal data. And there are different ways, I won't bore you with the details, but there are different ways the United States does this. In the national security area, there are the FISA warrants. So there's a special, I suppose I could call it a secret court, because it's not a court that's open to the public. It is staffed by federal judges. The United States government can go to the FISA court, get a FISA warrant, and obtain the data, including personal data, from companies like Facebook, Microsoft, and others, in order to protect the national security of the United States, protect against terrorism, and things like that. But that kind of access by the United States government, by the Department of Justice, to personal data is considered a violation of privacy and the rights of the EU personal data subjects, whose data is going to the United States. And so while everything else was fine, the national security interest of the United States that gave the United States access to the data was the problem, and was the complaint that Schrems brought his case based on to the European Court of Justice. And the European Court of Justice said that the Privacy Shield framework that was supposed to be an equivalent of an adequacy decision and would allow the transfer of data to the United States was not legal. And it wasn't legal because even though there were terrific arbitrators like myself involved in different levels of redress, and there were the architecture was fine, this national security issue came to the front, and that was the real problem. And so now, since the Schrems II decision and the end of the Privacy Shield, we have all of this uncertainty that is just terrible for commerce, because business has to go on. And that uncertainty has not yet been resolved. As you mentioned, there was an announcement, very brief, that appeared on the White House website in March of this year, saying that a tentative agreement had been reached between the United States and the European Union on a new plan. So we've had the safe harbor, which didn't work. We've had the privacy shield, which didn't work. And I'm not sure what we're going to call the new plan, but apparently we have the beginnings of a new plan, but there is no detail in that announcement. In fact, I believe it is literally 1 page or 2 pages and written in very big letters so that it looks like it's a long and substantive statement of what the agreement is. But in fact, there's nothing there other than an announcement. And so we'll have to see. So in the meantime, how do companies deal with this kind of thing? One of the practical consequences is that a lot of companies transferring to the United States have started to use end-to-end encryption for the transfer of their data. And it was one of the recommendations of the EDPB in November of 2020, just after the Schrems II decision. The EDPB issued some guidance about how to transfer data to the United States. And they said one thing you can do is use end-to-end encryption. And I suppose cross your fingers and hope that the NSA and the CIA cannot actually undo the end-to-end encryption along the way. But that's a practical step. And other than that, most of the clients that I have seen transferring data to the United States are still operating under the model clauses, the standard contractual clauses, SCCs, which the European Union has said provide adequate safeguards for data transfers. And so that is what I see most often.
Thank you very much, Alexander. That was very informative information. I'm sure a lot of us have benefited from that intervention. It wouldn't be end-to-end encryption if the NSA was able to get a hold of it, or would it?
Yes.
Yeah. So I'm just thinking, so there's nothing else that can be done. So with this uncertainty, it's just the usual safeguards, the adequacy decisions, the SCCs, and the binding corporate rules, and that should be it for now.
Yes, yeah. It comes down to the binding corporate rules and the SCCs, the standard contractual clauses, and those work. They are sufficient protections for the personal data that is being transferred. And so all the companies I work with are using those techniques. It's been quite a bit of work because during the Privacy Shield period until the Schrems II decision, the Privacy Shield was a very good method. It was quick, it was inexpensive, it required less internal work. You can imagine in a big company, in a big US company where all of a sudden you have to put in place a privacy and data protection infrastructure, appoint an officer in charge, figure out exactly what the EU law says, how to come into compliance, so the Privacy Shield was a very good solution, I'd say a quick and dirty solution for European companies. The solution now is standard contractual clauses and binding corporate rules.
All right, thank you very much. I have a question from the chat section. I'd like David Liu to take this question. The attendee is asking, countries are at varied data protection regulatory levels. What would be considered an adequate standard of protection, and where there is a lapse in protection, what sort of securities should be recommended? Would be helpful to have a checklist to help us better protect our clients. I think Alexander has answered that question. Perhaps David, could we have perhaps your views on that as well? Probably David is having some challenges. Peter, might you be able to supplement or give us your views in addition to what Alexander said and towards answering the question as well?
Just looking the question, which one is it? Sorry.
If I can read it again, it says countries are at varied data protection regulatory levels. What would be considered an adequate standard of protection, and where there is a lapse in protection, what sort of securities should be recommended? Would be helpful to have a checklist for their clients.
Yeah, okay. I mean, Switzerland, as I already said, is doing this kind of list or providing this kind of checklist that if you are a receiving country and you need to receive data from Switzerland, you can go to the website of this of the data protection office, and he has a checklist what shall be done, and there are some kind of guarantees in the local law that have to be fulfilled. That means, on the one hand, that there is a legal ground to collect data. On the other hand, also access to court in case in case data are collected about you, then you need to have access to the court. That are some provisions. Basically, that they are set out, and in general, I mean, to get an adequate standard of protection is I mean, that's a philosophical question at the end of the day. Switzerland quite very close to the European rules in order to be adequate. That was the point, and I think we have some standards. There is what I already said. There is this list in Switzerland, and you see that all countries from European Union, then I guess New Zealand, Australia are on the list as well. So if a country needs to consider to be on such a list as well, then I think it's the guideline which these countries have set, and at the end of the day, that would be helpful for these countries to get on the list at the end of the day.
Thank you very much, Peter. Utkarsh Bahuguna also had a question that was along those lines. I believe, Utkarsh, your question has been answered as well. There's a comment here, and it says, conflict for data privacy under cross-border companies can be first adjudicated as per law of the land, or it can be directly litigated under ICDR in case if the clauses of agreement is silent for arbitration clause. Do you agree, Alexander?
Let's see. I'm not sure I have access. Oh, let's see. Let's see. What is conflict for data privacy? Yes. So as I was saying, there are a number of different levels of adjudication that are available for redress under the Privacy Shield. There is redress from local courts. There's redress from a local U.S. government agency, the Federal Trade Commission. There are private agencies that provide dispute resolution. And I'd say the last step of redress, the last possibility is this arbitration procedure that was established by the ICDR, but that was never used. And so I think I counted once, and I think there are 6 or 7 different potential redresses. If you are a EU national and you want to complain about a privacy practice, a data protection practice in the United States, there are 6 or 7 different places you can go to make your claim and to get a remedy.
Thank you, Alexander. Just a final question, and perhaps someone else on the panel can take this one. It says, how best can state authorities strike a balance between the heckling test and the right to privacy? This has always posed out to be a threat. David, perhaps would you want to take that question? David Liu? Perhaps Leonor, you want to take that question since David is having some difficulty with his
Trying
mic.
to understand the question. How can best data authorities strike balance between ECLIN test? ECLIN test. I don't understand the meaning of the question, sorry.
Okay, perhaps any other panelists will be able to answer this question?
Yes, perhaps the person asking the question, or do we know exactly what the Hecklin test
is? We don't know. I don't know, at least.
And I don't know either.
Yes.
It's a legal test for obscenity.
Yeah,
that's what I found also just now.
Obscenity. Let me check.
Perhaps we can pack that question and we can take that later.
Maybe, Warimu, I'd like to ask, oh, I'm sorry, Peter, I was going to follow on to what Peter was saying just a few minutes ago about how we get, if you're a company looking to come into compliance, how you get into compliance, how you decide about binding corporate rules or standard contractual clauses. How do you get to that point? And is there a checklist for that or in connection with that assessment? And I wanted to point out simply that in the GDPR, there's Article 35, which provides for the preparation of an impact analysis. So in many cases, so it's called a DPIA, Data Protection Impact Analysis. And it is a way for a company to identify and assess all of the data protection risks that are presented. And the DPIA is performed either by the data protection officer of the company or by outside advisors and attorneys. And as part of the DPIA, the impact assessment, there will be at the end a recommendation about how the data should be transferred in the most safe and secure way outside of the European Union. And so while we can't give specifics about a particular company, Article 35 of the GDPR that is publicly available does provide a framework for a company that wants to perform this impact analysis and decide based on that analysis what the best course, whether it's standard contractual clauses or binding corporate rules or some other approach, is the best approach for that company. And there I recommend going to a privacy specialist and getting information about how to get that impact analysis done.
Thank you very much, Alexander, for the intervention. Just to pose another question from the attendees, are there any data protection policies that handle hacked end-to-end encryption? If not, then why? Are there any data protection policies that handle hacked end-to-end encryption? If not, then why? I don't see any concern with this because even if they didn't, you can always amend a policy and incorporate the necessary provisions. Perhaps there's a panelist.
Maybe even when you see or realize that the transmission has been hacked and the data has been disclosed or has been accessed by an unauthorized viewer or processor, that's a violation. That's a data protection breach, and EU legislation and Swiss legislation and or certainly also internal data provide for such breach. So you have to go back to the data subject whose name has been in this information and to inform them. You may also need to inform the regulator. So if your data has been hacked, that's the data breach, and the policies should provide on how to handle those breaches.
Okay, thank you very much, Christian. Perhaps I could have Seppo give his views on what we've been discussing with the rest, and perhaps just some cross-border data transfers and these safeguards that other jurisdictions are adopting to ensure that they're securing the data of individuals. Seppo, are you there?
Yes. If I take a short view about what I'm doing mainly in Finland, it's handling issues concerning business to business companies working inside European Union or from European Union outside European Union. And as it has been earlier said, we are using these standard contract clauses, SECs, and we are also trying to find out common DPA, data processing agreement. The problem I have today is that when I'm representing Finnish company working with some other company, we both have a little different DPA agreements, and then there is a discussion between these two companies that which one we shall use. And normally we will end up our model that is very strictly based on GDPR rules, and normally situation is so that GDPR based data processing agreement is giving the most security between these data transfers. But what I can see in the market is that there is a huge need to have some kind of international data processing agreements and confirmed standard contract clauses that could be used companies inside Europe, but also companies outside Europe and Europe. And that is a mess that there is so much rules inside GDPR that when you go to the level where you are making agreements between companies, there is so many different templates concerning DPA. If I say about our assortment, we have 19 different templates in Finland and 21 for international use. And we have also these tools, like Alexander said earlier, that you can make analysis of impacts for certain areas, or we have different kind of audit tools to auditing the system and other things. But we should have, I think, from European Union and Commission side, some specific common data processing agreement, standard contract clauses, and other thing that is giving security that companies really are fulfilling the minimum needs to handle these issues. Then issues about US and Europe, Alexander knows it, I think, best in this team, and there is challenges, but I hope that they can handle this issue about national security in United States. In Finland, normally, if you have issues like national security, you need to have some kind of decision from the government side that someone is suspected from tax fraud or some criminal things before you can get that kind of information. You cannot collect that kind of information from all citizens. You need to have some kind of decision that this guy is perhaps suspect for some criminal acts, and for that reason that kind of information can be collected. But as an overall, I think European Commission should some way simplify this issue so that companies could make similar DPA agreements and have similar standard contract clauses, and they are available for all the parties. Because just now, normally my customers has our model and some other company, one was from Switzerland also, they have their own. And then we was having 2-3 hours time to analyze both of these and making small changes and end up the result that was good for both of us. But I think this is stupid work. This is not the effective way to handle these issues. And in the end, I should say that European Union is doing this work to have a single digital market in Europe. But I think we are ending up quite soon a situation that digital market is global. And we should think about more about to have single global digital market and what's the minimum processes and other things to handle these cases, because just now it's giving too much work for the companies. But otherwise, I think there has been very excellent comments from this issue. So nothing else to add for that.
Yeah, indeed, Seppo, I agree. Do we envision a time when we'll have harmonized rules and harmonized regulations? It's definitely not. It's not going to happen, is it? Yeah. So we're still going to have. So. Yeah, we're still going to have these challenges for quite some time. We have another question. Perhaps I think Alexander can take this before we move on to the next topic, since he's the in-house arbitrator amongst us. There's a question from LinkedIn Live, and it's the attendee is asking, can a breach of a confidentiality agreement equal to an NDA, which from a legal nature is not equal to a commercial agreement or other binding document, be brought before an arbitration body or court?
So an NDA is an agreement just like any other agreement. And if there is an issue, a dispute that arises out of an NDA, it can go to arbitration either because there's an arbitration clause that can be included in the signed NDA, or the parties, once the dispute arises, can submit that dispute, just like they can submit any dispute, to binding arbitration at that time. And so I don't see that there's any reason to treat an NDA any differently from other kinds of agreements for the purposes of arbitration.
Correct. Yeah, thank you very much, Alexander. So moving on to the next segment, I'd like to direct this question to Bao. What are some of the emerging issues we're having in privacy and data protection?
Thank you. So the emerging issues, I think probably if I have to list, then there will be several. The first thing that I think Leonor has spoken earlier about the purpose of collections of the personal data. So I think we agree that most jurisdictions always come that the data processor needs to collect the personal data and inform the purpose of collecting these data. But the extent to which the purpose is permitted is still a very unclear scope. So here in Vietnam, well, what if a company, they're doing their, let's say, commercial polling, and they collect the information saying that they collect it for commercial polling, but then actually they use it for different purpose, but somehow interpreted it into the commercial polling. So the point is, the burden of proof, it's very hard to say, to draw a line where they violate the purpose of collecting the personal data. So I think that's the first point. The second one is about the overlapping regulatory authority. Here I think this is about a private nature clash with the public policies. So I guess we all agree that every jurisdiction gives a certain regulatory bodies the right to collect data without consent from the data subject. In Vietnam, there are about 12 to 13 governmental authorities that are capable of doing so. And their purpose is, again, remains very unclear on what extent or why they would require the personal data to be retrieved. And I think these are two main emerging issues. And the last one is about the illegal trading of data. So with the development of the e-commerce platform, so the unified system of information has allowed certain stakeholder, let's say some from credit institution, where they share the credit information of their clients to for the purpose of credit assessment. And then they use that information to do the marketing purpose, like opening credit cards or calling to the data subject for marketing purposes. And I think they are still doing so, even though the law somehow can interpret it that you can do it. So I think these are the main issues that I'm concerned about. But I would be very pleased if I can hear more about the audio, the other speakers with a different jurisdiction.
Here in Portugal, we face the same problems sometimes. So I believe it's common because we provide some personal data, for instance, for a car insurance. And days after, they contact us to offer other products related to somehow to the insurance company. I already filed some complaints in our regulator, and it's indeed a breach of the law. So here in Portugal, sometimes we face the same problems. Sometimes we receive several messages promoting, I don't know, supermarket products, and I never gave the companies my personal data. So I believe that they bought or they transfer somehow my personal data to that companies and to promote products, for instance. Here in Portugal, we sometimes face the same problems. Regarding the state organizations, the security measures are more effective. I believe that for instance, in COVID, we provide our personal data, our sensitive data. When we made the test COVID, the PCR, they collect our data and they contact us, but they inform us that our content will be storage only for that purpose. So I believe that the security measures in the public organizations are more effective. Nevertheless, in private companies, we are facing the same problems as my colleague described. I don't know why they have my personal data. I questioned the companies; they don't give me any answer because we have a lack of information regarding how our personal data should be treated. So we are facing the same problems as well.
All right,
Leonor, have your complaints been responded or somehow reacted by the supervision authority? Do they have any actions?
Yes, yes, we are starting now to promote to make more fiscalizations to the companies. We are publishing decisions regarding how your personal data should be treated. But as I mentioned before, it's a very slow procedure, very slow process. As I mentioned before, and I believe that is part of the solution. We need to create a more simple information so that people, when people read it, understand what they are reading. It's very important to do that. And we as lawyers is our main problem to explain the clients why they should do that, why do they need to proceed in a certain way, why they need to implement certain policies, certain procedures, but it's a slow process. But we are facing the same problems as you mentioned before. I believe in the small dimension, I believe that, but we are facing the same problems as well.
Thank you, Bao and Leonard, for those interventions. Perhaps, Christian, we can have your views on some of the emerging issues as well.
Sure. If you're a company and doing some global business today, then probably in the last months it has become a reality, and you have realized that there is many more countries and many more jurisdictions where your data may not be secure than you have thought before. And I think you have also realized that you have to really ensure with your own responsibility and with your contractual possibilities that the data you transfer to other jurisdictions for processing is being protected. And when wherever there are jurisdictions where agencies or governments or even empowered private persons can access personal data without the proper court, independent court deciding, you should make sure, or you should take much care not to transfer personal data. And in fact, in the business practice of companies, there is often an option to, for example, if they have an affiliate in some jurisdictions which, for example, produces software, or they have the option to transfer not real personal data. For example, when they need to do some testing with the software in this unsecured jurisdiction, they can also use masked data. They can come up with data which looks like personal data, but which is really not personal data. So they can properly test their system, and afterwards they can introduce it and have a properly tested system. For other purposes, for example, for statistics or for analysis, you don't need the personal data. You can take away the person from the data, and you can have it anonymously, even for medical purposes, which brings a lot of advantages. If you share medical data worldwide to medicine, you don't really need to add the personal ID to the data. You may need to add some personal parameters like age or health conditions, or some biographical data, but you don't need the name, because this data will only be used to come up with new statistics and for purposes of research. So there are many possibilities to avoid transferring personal data, where in the past companies just have transferred them in trust of the jurisdiction, of the destination of the data, that they will take care of data protection.
Thank you, Christian. I was just thinking about data localization as a restrictive policy, and the fact that it can make it infeasible to transfer data or it can require companies to store a copy locally or just obtain individual or government consent for you to be able to do a transfer. What are the effects of these? I would see data localization as an emerging issue, and just posing this question to Bao, what do you think are the effects of these data localization requirements on small businesses and, of course, on the global data economy? I think it would be definitely a very expensive venture for small businesses. They would not be able to afford this, but what would your perspective be on this, Bao?
Yeah, absolutely. It would raise a significant compliance cost, especially to those startups. So we assist several fintech companies who are startups, and they do the digital lending, peer-to-peer lending across cross-border countries. So they use the data systems from, let's say, a tech hub in Asia, like Singapore, and then they use that server like Amazon Global Service, and then back to Vietnam, where they set up their subsidiaries and they provide the services, connecting lenders and borrowers, and they collect the data from both lenders and borrowers, and then they transfer it back to the server placed in the Singapore. But the thing is, as of 2018, when the new cybersecurity law in Vietnam has been passed, and it's very debatable, a new requirement on local data localization has been put forward, and meaning that every onshore and offshore company, they have to, whenever they process the data by providing services, offering services in Vietnam, that they have to put a server in Vietnam to store the data and to be able to provide these data to the governmental authority upon request. And it raised significantly high compliance costs, and even put a constraint on the market access to new investment, because I think it's fair, because to maintain an infrastructure that allow them to comply with laws exceeds the budget that they would need to develop for their initiative here in Vietnam. And putting that forward, the government finally listens to the complaints and concerns about the startups, the SMEs, and these companies. And then they propose a new decree which limits the scope that applies, like which data that needs to be localized. So it's not every data, it's some of them. And then what circumstance that triggers the data localization? It means that if the law said in all circumstances, now they limit it to some circumstance whereby they get the information from the public that this data has been in breach, this data has been compromised, and at that time the localization will be triggered. So these are the new initiatives trying to minimize the cost of compliance. And I don't think that's only affects small businesses, but it affects even the giants, tech giants like Google, Facebook, Twitter, where they operate in a vast majority of jurisdictions all over the world. So I think it's a very big issue.
Right, because I see that more so for small businesses, it does definitely hinder progress and, you know, access to investment, or even just setting up businesses in different jurisdictions, if those are the requirements that businesses will now have in addition to what is already there. I suppose it would pose a challenge to some of them in terms at least of costs. Perhaps I can have Peter's perspective on this subtopic as well.
I think yes, certainly. I mean, the issues are, to be honest, the same everywhere in the world. I think we have the data protection. We are mostly lawyers or mainly lawyers. We find the same issues, and there was this question about unifying data protection law worldwide. That would be a great thing, actually, at the end of the day, to avoid also this kind of stupid discussion, as said, because that would be a field of practice where we could do that, and maybe we as practitioners should take efforts in this respect. So basically, we face here in Switzerland the same issues, and the point is, at the end of the day, according to me, or as practitioners, is those people who are trying to abuse the law, they are faster than the others, than the lawgivers or the practitioners. That's the point. Maybe we are sometimes on the same level with these people or this organization, this meta or big data collectors. That's the issue. At the end of the day, there must be a fair and equal equipment with I have the same issues. I get marketing emails, and when you go back to them, ask them, where did you get my address? It's not possible. It's all these kind of things that happens everywhere. But when you get 2-3 emails per day, you are not going to sue. That's also an issue. So basically, we should as practitioners elaborate new mechanism to protect the data, really to fight against these huge companies, to avoid this big data and all these kind of things. But for me, I'm only a practitioner, but there must be some initiatives from our side.
Yeah, indeed. Where do we see data protection in 2, 3, or maybe 5 years from now, and what opportunities can we foresee for lawyers moving forward? Perhaps Monia would want to give us maybe 1 or 2 of that, and Alexander can add on.
Well, I hope that we will be more developed relating to the data protection, and I hope also that because there are too many rules, I think, so maybe having a guidance of compliance checklist for organizations to trivialize the data protection and to allow a better protection of personal data. That's where I hope to see the data protection in the future.
Right, thank you. Alexander, could you kindly give us your views on that as well?
Yes, so I'm afraid that the whole subject of data protection is subject to many of the larger questions of geopolitics. And you asked earlier about whether we might be moving towards a harmonized global regime of data privacy. And I'm afraid we're going in the other direction. Since the fall of the Soviet Union, I think there was some hope that there would be some emerging one world global harmony, and many people work towards that. We seem to be going in the other direction right now, whether it's regional trading blocks or definite isolation, whether provoked by the Ukraine war or policies in China. And I think those will get worse. And I'm not sure what the world is going to look like in 3 years on those geopolitical issues, but I'm afraid that data protection issues are going to follow those geopolitical movements, and it will be harder to transfer data. There will be greater conditions for transferring data out of the European Union. out of trading blocks between the EU and the United States, for example, to go to China. And that will bring increasing regulatory compliance on companies, and they will need more assistance on data privacy issues from their council, on impact analysis, and the council will need to be familiar with these geopolitical issues in order to frame and understand the political risks that are presented in data transfers across borders. So if anything, I'm afraid things are going to be more difficult, but there are opportunities for advisors, opportunities for councils, and there are ways for companies to limit the risks that they are exposed to.
Right, definitely, I agree. In fact, I think I'm more inclined to believe that there will definitely be a rise in trading blocks, because it will be easier, especially speaking from a Kenyan perspective, it will be easier for us to come together. I come from the eastern side of Africa, so maybe Eastern Africa can come together. There's already a block here, or maybe certain blocks will be coming together to just ensure that business moves forward and trade as well. Geopolitical movements, yes, a bit more complex, but as lawyers, yes, we are trained to be up to date with current affairs. So I guess that's something that we have to do. I do agree with the increasing regulatory compliance as well. I'm really looking forward to more harmonized rules and regulations, filling in a lot of these legal lacunas that are there and uncertainties as well over time. I think also over time we'll probably, like Monia said, the checklist for sure. I think some things will definitely be more clear than they are right now. Any more interventions from the panel? Perhaps Christian?
Not much to add. It's very good how you summed up already, and I fully support that. And I just want to state too that there is no problem you cannot overcome, and it's certainly our mission is to help business to do their business in a compliant way, and to do it in a global way.
Right. Seppo, might you have any views on the same as well?
Maybe one comment is that we have two possible ways. Either we are harmonizing this legislation, or then we go to other side and there will be a blocks. And for that reason, we should have from the European Commission some kind of guidelines. What are the rules or steps needed if we are making business from European Union countries to some other blocks? For instance, if I have as a customer coming from Finland and the other party is, for instance, I say Rason, even there is a situation now, but there is needed to have some kind of instructions for the companies and also for lawyers that is it possible to transfer data from European Union to Rason, and if it is possible, what kind of steps you need to have, and if they are not fulfilled, is it then not possible to transfer the data? Because that is what the companies need, and also lawyers who are guiding the companies should have this kind of support from European Union and Commission. And so we could have so-called plan A and plan B, and as Alexander said, plan B should be the realistic future, and then we need to have some kind of guidelines, because it's not good that every lawyer is making this from own mind, that what is needed and what is not needed. So that's all.
Okay, thank you, Seppo. I definitely agree. I can say definitely from a Kenyan perspective, you guys are definitely steps ahead. I would say we're an emerging market like Vietnam and Portugal, and we would definitely see at least more clarity in our laws and our regulations, a lot of more supplementary legislation, guidance notes, policy coming up as well, just to provide clarity in terms of compliance. A lot of countries in Africa, Kenya being one of them, Uganda, Tanzania, Morocco, Egypt, South Africa already have data protection laws in place. Regulatory offices have been set up, been funded by the respective governments, and some underfunded like ours, but a lot has been done trying to make steps in the right direction towards complying with what especially you guys in the EU are doing. So in terms of Kenya, I definitely just see a lot. So a lot of just harmonization in our laws, companies stepping up and complying with those laws as well. And it's great that we had this session because we're able to do some comparative analysis with what you guys who are a couple of steps ahead of us are doing. Yeah, I think we have come to the end of today's conference. Thank you so much. Very big thank you to all the panelists for your time and for taking part in this panel. I've definitely learned a lot. I'm sure the attendees have as well. We've taken away quite a bit. I look forward to more collaborations and future engagements with you all in different spaces. There's been quite a bit of activity in the chat and the Q&A section, and I can see people have been trying to. I hope they've also picked something out. Thank you to the attendees for being with us today as well. I do hope you were able to follow and take away a thing or two. Many thanks to the World Law Alliance Secretariat for bringing us together, especially Gayatri. I must acknowledge that, for bringing the respective law firms within the Alliance together and making this conference possible. We really couldn't have without you. Thank you so much. Well, I suppose that concludes the session, the conference today. So with that, thank you very much for being with us. And here is to wishing you a good day. Thanks once again, and best wishes.
Thank you.
Thank you.
Thank you.
Thank you very much,
Thank you.
everyone.
Bye-bye.
Thank you.
Bye-bye.
Thank you. Thank you.
Thank you for organizing.
Thank you.